right. And the final question is, when is it appropriate to request a GAL? Well, and sometimes you don't the question of timing is irrelevant because in Cook County the process that's supposed to be followed, and so a majority of judges do, not all, but a majority of judges do follow this process, which is you appoint the parents to see a mediator. To go to mediation, the mediator is either really good or really bad. It's hit or miss. And if it's great and they get done, boom, we draft the allocation judgment, parenting plan, they sign it, and they're done. They don't have to deal with having a GAL appointed. But other judges, if the mediator's report comes back and says, nope, we didn't resolve all issues, or even one issue, the judge, it's not even like there's any discrepancy. The judge just orders a GAL right then and there, and you're done. I'll see you in 6 months, really. So the GAL can conduct their investigation. So you don't get a lot of choice in that. Therefore, the timing, when is it appropriate to request a GAL? Well, it doesn't matter. You get told when you have the GAL. Now, let's say it's post-decree and, I don't know, mediation hasn't worked in the past, so you're going to skip mediation. Then you can file a motion to request a GAL be appointed to investigate either a very specific issue regarding medical, like sleep apnea. This is actually a case I had. The mom thought the kid needed some help with sleep apnea, and the dad didn't. We had multiple medical records. The judge was finally like, whatever, just get a GAL, have the GAL look at it, tell me what to do. So that's what we did. We got a GAL appointed to make that determination. Others is a bit more complicated. But the one thing that you must have in place before you can even ask the court to have a GAL appointed is there must be a pleading pending that deals with significant decision-making or parenting time allegations. So you can't first motion for a GAL and then file that. That would be the cart before the horse. Instead, you got to have that motion pending. So if the matter had been off call for 2-3 years or whatever, and then suddenly I as an attorney get a phone call from dad saying mom's new boyfriend hit my son with a belt, we need to get a GAL to investigate this guy, what's going on, I would have to file an emergency motion to suspend parenting time with mom when that boyfriend is around, and then file a motion to appoint a GAL at that point. And maybe even the judge at the hearing for that emergency motion might recommend or order a GAL to be appointed right there without needing to have a formal pleading filed. But in that case, that's when it would be appropriate and timely to ask for a GAL. But first, I couldn't file the motion for the GAL. I'd first have to file that emergency motion, and that's how you would be able to appoint or request that the judge appoint one.